Fine.
Yes.
Item.
12, madam.
1 second. Stenographer. ये इसको बुलाइए. One second, Mr. Suri. PS is not here. You want to mention item number 12? You were supposed to take steps.
We have taken the steps, madam. And
Ms. Sakya, why are you making a mention of an order matter? Wait, we'll reach to the order matter. Let us have the fight. Just wait for you.
Because madam, the counsel for the respondent is also out of the session.
That's all right. You are supposed to take steps. Just wait for some time. Unless you have some other engagement, we shall accommodate. 1 second, ma'am. Yes.
Your Lordship, I would like to mention item number 23.
Item number
23.
20.
3.
Yes.
And recently I have provided a paper book.
You are the amicus.
Yes, Your Honor.
You have been provided.
Yes, recently
When do you want to do it?
on 13 May.
On 13.
Yes.
You are O.
Bingep.
Bingep.
Yes.
MS O. Bingep, learned amicus curiae, submits that she has been recently handed over with the paper book. Stop. Accordingly, she seeks some accommodation in the matter. This matter on 13/5/2024. Call for the list. You want to make a mention?
My lord, I would like to mention item number 4 and 13.
13, you wait for your turn, and in item number 4, yes, 4 is an RSA. What do you want?
My learned counsel has gone for eye treatment. So doctor has suggested to take rest at least for
You are
45
seeking
days.
adjournment on behalf of the appellant.
No,
Uh,
I am
here-
for the appellant,
here
for
on
the
this-
Do
respondent.
you have
Yes,
any
respondent, yes.
objection?
It's all right, Lordship.
All right. As prayed for by Mr.
Subbu Koyang, sir.
So-and-so, learned counsel for the respondent, which is not objected by Mr. So-and-so appearing on behalf of the appellant, list this matter after,
4 week, man.
Lordship as a fixed matter, because today also it was.
list
fixed
this matter on
29th of this month.
29/5/2024.
My lord, it would be difficult for the learned counsel because he is on,
Medical.
yes,
Yes, when can he appear?
after 4 weeks, my lord.
Then, Lordship,
Anyway, you make a prayer on that date. We'll see.
yes.
All right. In the meantime, alternative arrangements can be made because this matter needs to be admitted. This matter is
Yes.
not going to be taken up for hearing. Yes.
Because this is the last year already, since
All right.
2023.
We are accommodating you today. Next time you make an or either you appear or you make alternative arrangement.
Yes, sir.
This is made clear to you. Yes.
And my lord, item number.
Order matters, wait for the turn.
Okay, yes.
Call the list.
My lord, I
Yes, item 1.
mention.
Item number 1. Yes, Mr. Ite, what is this? This is
Yes,
under
Lordship.
the-
Yeah, it's an interesting one, Your Lordship.
under the provisions of the AP Excise Act.
Yes, Your Lordship. So now the question here is whether the FIR before the police will lie or not. This is the issue here. And Your Lordship, so far as the AP code is concerned, the procedure, everything is comprehensively prescribed in the Arunachal Pradesh Excise Act 1983.
It's a complete code.
Yes, sir. Volume 7, Your Lordship.
Now here the FIR has been filed under the provisions of
Your Lordship,
34(1)(a). Where do I get the, it is here,
volume 7, Your Lordship.
volume 7. Page,
Your Lordship, it's in board section 34. It's in page number 80. 80.
80.
Yes, Your Lordship.
Yes.
Lordship, for me, Lordship.
With the FIR, the type would be is page number 14. Okay?
Page number?
14.
Yes.
Actually, the gist of the FIR is that on 20 March 2024, a team of police and excise officers, they conducted a raid. And accordingly, a wine show was conducted, and therein it was found that the wine show was functioning from a different place apart from where the license was granted. Basing on this, an FIR was registered in Itanagar Police Station, FIR number 44 of 2024 under section 34A of the Arunachal Pradesh Excise Act.
Okay.
Lordship, the section 34 provide, if I may read.
You are challenging, you are seeking quashing of this FIR.
FIR.
On what ground?
On the limited ground, Lordship, that the Arunachal Pradesh Excise Act, it provides a complete mechanism at how any penal provision that may arise under this act may be acted upon. If I may, my lord,
Yes.
Section 66 of this act,
First, what is 34?
34, my lord, if I may read.
Yes,
34,
please.
if any person in contravention of this act or any rule, notification or order made, issued or given license, permit or pass granted under this act, imports, exports, transport, manufactures, possesses or sales any intoxicant. So according to the FIR, some intoxicants were found in my wine shop.
So according to the FIR, these were sold in another place, not in the place in which it was permitted to sell, correct?
Yes, your lordship.
That is the gist of the allegation.
Yes, this is.
So under that, prima facie offense under section 34 is made out.
Yes, yes.
Now you are challenging the procedure part.
Yes.
Yes. What are you saying in that regard? Section?
In this regard, my lord, if my lord may come to section 66, my lord.
Yes.
Now, section 66, it provides that any collector or excise officer empowered under section 65 subsection 2 may, after recording in writing his reason for suspecting the commission of an offense which he is empowered to investigate. Now, section 66 contains the complete procedure as to how any offense in this regard to this act is to be investigated. Because, my lord, in subsection 3, an excise officer is deemed to be an officer in charge, and the area concerned is deemed to be a jurisdictional police station. Now, if I may, my lord, if I may read subsection 4 of section 66.
So the excise officer will be deemed to be a police officer.
Yeah, he is the police officer, he officer in charge of the concern.
Okay.
If I may read section 4, subsection 4.
Yes.
As soon as investigation by a collector or by an excise officer empowered under section 65 subsection 2 has been completed, if it appears that there is sufficient evidence to justify the forwarding of the accused to a magistrate, the investigating officer, unless he proceeds under subsection 2 of this act section, wherein they are empowered to stop the investigation if they deem it proper, or under section 56 of this act, wherein they have been given the power to compound the offense, shall submit a report which shall, for the purpose of section 190 of the Code of Criminal Procedure 1973, be deemed to be a police report to a magistrate having jurisdiction to inquire into or try the case and empowered to take cognizance of offences on police. Now, if my lord will come to section 75, herein, initiation of certain prosecutions.
Yes.
If I may read, my lord, section 75.
Yeah.
No magistrate shall take cognizance of an offence referred to in section 34, wherein I am under which I am charged. Section 37, section 43, or section 44, except on his own knowledge or suspicion, or on the complaint or report of an excise
So
officer.
how cognizance is to be taken is given.
Yes, yes.
It is either on his own knowledge or suspicion, or on the complaint or report of an excise officer,
Yes.
or an officer empowered in this behalf by the state government.
So now,
There's no complaint.
a complaint on the complaint or report of the excise officer.
So
But-
no, but now here, this is a complaint to the OC.
Yes, sir.
Now here it appears that it has been received and registered,
Yes, sir.
but whether subsection, whether subclause A of section 75 is fulfilled or not is not made out.
That is our.
That is your case, isn't it? Because it does not appear that satisfaction has been generated.
Here, your lordship, to be very simplify, your lordship, here the power of the excise officer is either he can investigate the matter by himself and file a report. That is under report under 173 nature, your lordship, because everything has been given under 160 to 171. Every under CRPC procedure can be followed. And after completion of the investigation, he can file a report. And basing on
If
that,
he files a report, in that situation, 75 will come into play.
75 will come when report filed, and he can directly approach the magistrate also by way of complaint. And complaint is governed under chapter 15 of the CRPC under section 200. The chapter 15 procedure will be followed if he approached the magistrate directly under section 200. Your lordship,
But in that case, perhaps the records would be required to see what has happened.
yes, your lordship, record, yes, maybe call for your lordship.
Because otherwise at page 14, from page 14, it cannot be generated whether these satisfactions has been generated or it is just mechanically registering a case.
Yes.
Lordship, in that regard, our submission is that Lordship, that the excess officer, the respondent number 2 hearing, could not have filed an FIR report or OC. He is a police officer himself. So either he could have investigated the contravention this issue,
Yes.
and he could have filed a charge sheet before the concerned magistrate, or he could have directly approached the magistrate under section 200 by filing a complaint. Lordship, the FIR it is our submission that the FIR is not maintained. There is an express legal bar whereby FIR is not to be.
All right, we will stay this FIR then
Yes, your lordship.
till the next date. In the meantime, let the record be produced.
Yes, your lordship. Yes, yes.
Yama, please take down. Heard Mr.
Jitalo.
So-and-so learned counsel for the petitioner, also heard Mr. T. Ite, learned APP for the state respondent. Stop. By filing the instant application under section 482 of the CRPC, the petitioner is seeking quashing of Itanagar Police Station FIR number 44 of 2024 under section 34(1) AP Excise Act 1993 and the corresponding Itanagar Police Station case number 44 of 2024 registered under section 34(1) of Arunachal Pradesh Excise Act 1993. Stop. It appears, don't say it, okay? The case of the prosecution, the case of the petitioner is that an investigation against the petitioner is being undertaken in connection with the aforesaid FIR lodged by the respondent number 2, i.e. Assistant Inspector, Tax and Excise, within bracket, narcotic, under the provisions of section 34(1) of the AP Excise Act 1993. Stop. It is submitted by Mr. So-and-so learned counsel for the petitioner that the impugned FIR and the investigation undertaken is illegal and untenable in law, inasmuch as an investigation of an offense under section 34 of the AP Excise Act is to be investigated by a collector or an excise officer. Stop. He further submits that the power to investigate an offense flows from section 66 of the AP Excise Act 1993. Stop. He further submits that under section 75 of the said act, it is provided that no magistrate shall take cognizance of an offense referred to under section 34 except on his own knowledge or suspicion or on the complaint or report of an excise officer or an officer empowered in this behalf by the state government vis-a-vis an FIR registered under Section 34 AP Excise Act. Stop. Correct. This are your submissions. Mr. T. Ete, learned APP for the state respondent submits that the records,
Yes,
records,
yes, your lordship,
records of
records of the pertains to the, your lordship, this FIR, your lordship.
records
with-
in relation to the Itanagar PS case number 44 of 2024 is required to be called in order to ascertain whether the procedure mandated under the AP Excise Act has been followed or not.
Yes.
Stop. Issue notice. Returnable 2 weeks. You'll accept on behalf of.
Yes, your lordship, I will accept on behalf of one state only, your lordship.
Two will be by registered.
Yes,
Stop. Mr. T. Ete, learned APP for the state accepts total on behalf of R1 extra copies within the course of the day. Steps in respect of R2 to be taken by registered AD within a period of 2 days from today. Stop. Section 66 and Section 75 of the AP Excise Act 1993 is reproduced hereunder for ready reference. Stop. You reproduce them. Huh? It appears from subsection 4 of Section 66 that upon an investigation under Section 65 is completed by the collector or by the excise officer, and upon completion of such investigation, if it appears that there is sufficient evidence to justify the forwarding of the accused to a magistrate, the investigating officer shall submit a report for the purpose of Section 190 of the CRPC, which shall be deemed to be a police report to the jurisdictional magistrate to inquire and try the case. Stop. Yama, where you are reproducing 65, 66, and 75. Okay. In the present case, it appears that the assistant inspector lodged the FIR in the police station
yes,
before the jurisdictional officer in charge by communication dated, what is the date? 23/2024. And upon receiving the said FIR, a case has been registered against the petitioner under Section 34A of the AP Excise Act. Stop. Prima facie, it appears that the procedure contemplated under the provisions of the AP Excise Act has not been followed.
yes,
Stop. Situated thus, this court is of the considered view that in the interim, further proceedings of Itanagar Police Station FIR number so and so under section so and corresponding Itanagar Police Station case number so under so be stayed till the next day.
Yes.
Stop. This you will get at page 7, the details. List after 2 weeks on a date to be fixed by the registry.
Deeply obliged.
Give that book to Yama. Some compromise has happened here.
Yes, sir.
Yes, Mr. Ite, can it be quashed on the basis of the complaint, compromise?
Yes, your lordship. In the same situation case for the sections, penal provisions, this honorable court in the earlier occasion also, your lordship, quashed the matter when they settled the matter
The-
entirely among themselves.
Settlement is at page 16.
Page 16, Lordship, and Excess C, page 16.
It was an accident, perhaps. Your lordship.
Hmm. So there was a KEBA proceedings where both the parties have attended and the members and the KEBA members had mediated
Yes.
and got the
Settled.
matter
Yes,
settled,
sorted, yeah.
correct?
Yes, your lordship.
And this is filed jointly.
Yes, between the accused and the complainant
There are
victim.
two affidavits. Both has filed affidavit, right?
Yes,
Who is the complainant? Petitioner number
one, your lordship. Complainant victim, Marco Bojir.
is the complainant
Yes, complainant victim,
and two is the accused.
accused. Your lordship.
Okay. Yama, item number 2. Heard Mr. D. Boje,
Yeah, Lord.
learned counsel for the petitioner stop. Also heard Mr. T. Ite, learned APP for the state respondent stop. This is a joint application filed by the complainant stroke victim and the by the and the accused with a under section 482 CRPC for quashing and setting aside FIR dated 4/1/2024 Vide Likabali PS case number 1 of 2024 registered under section 279, 337, 338 IPC on the ground that there has been a mutual settlement between the parties and in view of the amicable settlement arrived between the parties do not want to pursue the matter further. Stop. Heard the parties, stop. It appears that a mutual settlement agreement between the parties has been enclosed to the joint application filed by the petitioner as Annexure C, accompanied by affidavit sworn both by the complainant stroke victim stroke petitioner number 1 and the accused stroke petitioner number 2. Stop. Stop. Next paragraph. A perusal of the aforesaid mutual agreement and mutual settlement indicates that a KEBA proceedings have been held to mediate the differences arose between the parties, and pursuant to such proceedings, settlement has been arrived between the parties. Stop. It appears that both the parties have agreed and accepted the decision of the KEBA members, and pursuant to such compromise, the joint application has been filed. Stop. Next paragraph. In view of the aforesaid settlement arrived between the parties, comma, for the ends of justice, this court deems appropriate to set aside and quash the FIR dated 4/1/2024 Vide Likabali PS case number 1 of 2024 registered under section 279, 337, 338 IPC. And the any criminal proceeding is going on. That is all, if I say,
It's in, yes, not required, your lordship, because it's in investigation stage only.
stop. As such, disposed of.
Deeply obliged, sir.
Highly obliged, Lordship. May it please, Lordship?
This
My
is
lord, this is-
AG,
Yes, my lord.
Ms. Hege, case diary would be required
Lordship,
Monday,
Lordship, Tuesday, Lordship then.
Tuesday.
My lord, it will not possible to receive the copy of the CD on Tuesday.
Why
Yes,
are
from
you
my drop-
undermining the APP? The APP is confident
Yes.
and the court has full confidence on the APP.
If
I'm
possible,
sure he
other
will
than,
get it.
Lordship, if Monday, Tuesday is not reached, then on some other day it will be fixed.
Tuesday,
Lordship,
call for CD, list this matter on Tuesday.
Obliged.
obliged.
Joint compromise is there in this matter. Who is appearing for the state? Yes, Mr. Vaidya, why are you standing for so long? Why are you not sitting down? There are enough seats. Yes,
Lordship, the petition is under court at T2 of CRPC. Joint petition by victim, complainant, and
where is the settlement? Page 50.
yes.
Affidavit is filed by both.
Lordship. Affidavit is filed by the accused person and authorized by the victim and complainant.
Victim has not filed affidavit.
No, Lordship.
Yes, MS Hege. What do you have to say?
Lordship, the joint petition is there, then what should be filed affidavit, Lordship?
Where is the affidavit of the victim?
Lordship, they have authorized,
Authorized,
it is on page number
authorization will not,
page number
you
15.
file an affidavit on her behalf. It appears that the affidavit of the victim stroke petitioner number
2N.
to the victim, the affidavit of the victim is not. No, you say like this, cut that. It appears from the joint application filed by the petitioners for quashing the subject FIR is not accompanied by an affidavit on behalf of, or affidavit sworn by the complainant stroke victim. Stop. Let an affidavit be filed by the victim to this effect. List after
1 week.
1 week on a date to be fixed by the registry.
Lordship, interim is your interim.
Interim, if any, shall continue till the next date.
Obliged.
Item 6.
May I please,
Affidavit.
my lord,
Have you filed the?
my lord, I'm sorry, my lord, I could
No,
not.
no, here I think there is a note of the registry that there has been some defect
Yes,
in the petition. So you get the defects rectified. This court cannot proceed with the note of the registry. The accused or authorized person has not signed at page 3, which is relevant. However, look at it, there is some defect.
we'll have
It appears from the note of the registry that there has, that defect has been found in the petition. Stop. Let the same be corrected and placed before the court.
my lord,
Let the same be corrected, and only after correction of the same, the matter be listed before this court.
my lord, may I please, my lord, in fact, my lord, they have filed another additional affidavit, my
Huh?
lord. They have filed another additional affidavit, my lord. And to counter this additional affidavit, as well as, my lord, that just to bring on
Mr.
record.
Kato, you have heard the order of the court.
My lord.
There is defect in this petition.
My lord.
Unless that defect is rectified, this court cannot pass any other judicial order. Yes.
Please, my lords.
Yes, in item 7. Yes, Mr. Getso, service I think is still to be
No, no, we
completed.
have taken.
You have taken,
steps.
but the office note indicates it is not yet complete. All right. Await service report in respect of R2. Stop list after 3 weeks.
As per his convenience, Lordship.
Yes,
Your Lordship.
list after 3 weeks on a date to be fixed by the registry.
Obliged.
Obliged.
Yes, Mr. Ite.
Your Lordship, here in this case, a number of opportunity has been afforded to the accused to appear before the IO.
He's not appearing.
Your Lordship, it appeared, Your Lordship, but not on the date which was fixed by this court. Your Lordship may kindly come to the order dated 4/4/2024. Your Lordship.
Initially, interim was given
Yes.
on 1/2.
Oh, it
Okay,
was
you
granted on
want,
9
anyway, you are drawing attention of this court to order it.
on 4/4. So that, Your
4/4.
Lordship, yes, even if bail is granted today, Your Lordship, the strict direction may be, condition may be imposed because of the conduct of the accused, Your Lordship.
4/4.
Yes, 4/4/2024.
Yes, yes.
Your Lordship may find in paragraph, Your Lordship, be that it may, Your Lordship.
Yes.
Be that it may, for the ends of justice and view of the submission made by the learned counsel for the applicant, the accused is given one more chance to appear before IO. Accordingly, the accused is directed to appear before the IO of the case on 10/4/24 at 10 a.m. It is made clear that in the event the accused failed to appear before IO on the case on 10/4/2024 at 10 a.m. as directed, the interim anticipatory bail granted to him on 9/1/24 and the subsequent order for extension shall is then automatically
Did he-
cancelled.
Did he appear on 10/4?
On 10th, he didn't appear, Your Lordship. As per the case diary, I have received the case diary, updated case diary, Your Lordship.
Did he subsequently appear?
And on, Your Lordship, 22nd, Your Lordship, the matter was fixed. However, they have taken time from this honorable court and the interim was continued.
Till now, they have not appeared.
After that, Your Lordship, they have appeared on 25th, Your Lordship. Oh, Your Lordship, on 25th, 4/2024, Your Lordship.
On
Accused appeared.
22nd, why this was not pointed before this court?
Your Lordship, I'm extremely sorry, Your
You were not
Lordship.
there,
I was not there, and it is their
That
duty
is,
also.
If this was pointed out, we would have cancelled. that
Exactly, Your
bail.
Lordship. That is the reason I'm drawing Your Lordship attention here, Your Lordship.
Bail will get cancelled. What is this kind of conduct? So many times, it has been provided for you to appear. This is not correct. You cannot be taking interim orders and not appear before the IO. Such conduct cannot be tolerated by this court. Absolutely not correct. Interim orders are given for the benefit of the accused so that the accused go appear and cooperate. But you are taking undue advantage of the interim order granted by this court.
Yes.
How can this be done? Where is the FIR? And why this order was not brought to the notice of the court on the last date? You see, the court takes every word that is being said by the members of the bar very seriously. Neither the state nor you had pointed out that the orders of this court has not been followed. On that day, this should have been pointed out. Otherwise, extension would not have been granted.
Yes, Your Lordship. Your Lordship,
Where is the FIR?
the type copy is in page number 11, Your Lordship.
What is the gist of the FIR?
Your Lordship, this fraudulently taken, Your Lordship, the signature, this check which was, your lordship, alleged by the deputy.
85 lakhs.
Yes, your lordship, but it was not drawn, your lordship. No doubt it was not drawn, but as per the, your lordship, the deputy commissioner, the signature was forged, your lordship.
Subsequently, they have appeared.
By the time on the first date when interim was
On
granted,
25, 4/24, the petitioner appeared before the IO.
this is the last, 25 is the last recently, your lordship. And
Correct.
yes,
Did he appear?
yeah, he appeared, your
He
lordship.
appeared and his statement has been
The
recorded.
statement, the same statement, your lordship. The earlier the statement whichever he has given, the same statement he was given. He had given the same statement.
Anything adverse found?
Your lordship, only the statement is that he has taken check from the one of the employee who is there in the DC office, who has given him the check. That is the, your lordship, his statement, and he is not disclosing the name or identifying that person who has issued the, who has given him the check. Only here the concern is regarding his conduct, your lordship. He is, although so much leniency has been shown by this honorable court, he is not cooperating with the investigation.
No, your lordship, the
All right,
applicant
this is item number
8.
8.
8, your lordship.
Heard MS
W. Janav, Your Honor.
as your name is not reflected in the cause list.
I'm on behalf of the conducted counsel, Your Honor.
MS so and so, learned counsel for the petitioner. Stop. Also heard Mr. T. Ite, learned APP for the state respondent. Stop. This is an application under section 438 of CRPC 1973 for grant of pre-arrest bail to the alleged accused applicant, Shri Gida Panyo, who is apprehending arrest in connection with Doimuk Police Station case number 2 of 2024, registered under section 468 of IPC. Stop. Pertinent to state that by order dated 9/1/2024, the petitioner was granted interim pre-arrest bail subject to the condition that the petitioner shall appear before the investigating officer for interrogation. Stop. It appears from the case diary placed before this court that the accused petitioner has been deliberately avoiding appearance before the investigating officer after obtaining interim bail from this court. Stop. Further, it appears that on number of times, the number of occasion it was extended, no?
Yes, sir.
Number of time, the bail granted, interim bail granted to the petitioner was extended, directing the petitioner to
Yeah.
appear before the investigating officer. Semicolon. However, the petitioner avoided appearing before the investigating officer. Stop. It further appears that on 4/4/2024, this court directed the petitioner to appear before the investigating officer of the case on 10/4/2024, and further this court was pleased to make it clear that in the event the accused fails to appear before the investigating officer of the case on 10/4/2024 at 10 a.m., the interim pre-arrest bail granted to him by order dated 9/1/2024 and the subsequent order of extensions shall stand automatically cancelled. Stop. Surprisingly, the petitioner, despite the said order dated 4/4/2024, did not appear before the investigating officer. Stop. In view of the petitioner's non-appearance on 10/4/2024, the interim bail granted earlier ought to have been cancelled. Stop. However, when this case was listed before this court on 22/4/2024, the aforesaid facts was not brought to the notice of this court, for which the interim order passed earlier was directed to be continued till
Till then.
today.
Yes, sir.
Stop. It may further be pointed out that thereafter, the petitioner appeared before the investigating officer on 25/4/2024 and got his statement recorded under section 161 of CRPC.
Yes, sir.
Stop. Mr. T. Ite, learned APP for the state respondent, submits that the petitioner has been that the petitioner was not cooperating with the investigation and has been taking undue advantage of the interim pre-arrest order granted by this court, and further that the petitioner has not deposited the checks,
Your Lordship, not disclose the name of the accused, Your Lordship.
has not disclosed
The name of the co-accused,
the
Your Lordship.
names of the co-accused. Stop. In view of the aforesaid submission made by the learned APP and the materials available in this case diary, it appears that the petitioner is not cooperating with the investigation. Stop. As such, this court is not inclined to grant the privilege of pre-arrest bail to the petitioner at this stage. Stop. The prayer for pre-arrest bail stands rejected. Resultantly, the interim pre-arrest bail order granted by order dated 9/1/2024 and the subsequent orders for extension stands cancelled. With the aforesaid direction and observation, the present AV stands disposed of.
Deeply obliged.
Sorry. Yes, steps were supposed to taken
Yes,
in
sir.
this matter. Why R2?
Your Lordship, it's a POXO matter, Your Lordship.
Oh, so R2, you
If
have
I-
not taken steps till now.
I have taken, so far my
So
knowledge.
the office note dated 1/5/24 indicates that steps has not been taken, but be that as it may, there's a POXO matter.
Yes, Your Lordship.
Then I think it has to be done through the
Yes, sir.
IO.
Yes, Your Lordship. They will take step in the
That the offense involved in the bail application involves offenses under the POXO Act, let a copy of the petition be served by the petitioner to the office of the APP,
Yep.
who shall thereafter forward it to the concerned jurisdictional IO
Yes.
for
For the-
furnishing the same to the respondent number two
Two.
stroke victim,
Yeah, father of the
Father of
victim.
the
father
victim.
of the victim.
Yes.
Stop. Needless to clarify that it is the responsibility of the jurisdictional IO to have the copy served upon respondent number two and thereafter file a report before this honorable court. Stop. List this matter after 2 weeks on a date to be fixed by the registry.
Deeply obliged, Your Lordship.
Yes,
CD was called for with FSL report.
CDA, right?
Lordship, CD was there, but FSL report was still awaited, Lordship. FSL report is still
When was it?
awaited.
Come from Kolkata actually.
So it will take some time,
Some
Lordship.
time is required.
You're on interim.
Yes.
Okay. Await FSL report. List this matter
3 weeks, Lordship.
After 3 weeks on a date to be fixed by the registry, interim order passed earlier shall continue till then. You have received the CD, no?
Lordship, CD is there, but updated CD may be called for then, Lordship.
In the meantime, let the up-to-date CD be
Lordship,
also called
Call
for.
for, Lordship. Obliged, Lordship.
Yes, this is a transfer petition. Objection filed.
Your Honors, we need more time to file
All right.
objection.
You are Mr.
Endoji.
Mr. So-and-so learned counsel for the respondent
Yes.
seeks 2 weeks' time to file the necessary objection in the matter. Stop prayer not opposed. List this matter after 2 weeks on a date to be fixed by the registry.
Your Honor, interim may be continued.
Interim, if any, shall continue till the next date. Steps, Mr. Saikia, have you taken?
Yes, madam. I have served a copy to the council of the madam.
No, because you see, there is an office note of first 1-5, that steps not yet taken in respect of R2.
Yes, ma'am. In fact, my lord, R2 has filed the implement application through Mr. Dhruva Sethi, the council of the rest of the, my lord, respondents, my lord. So we have agreed, my lord, and he has received.
No,
the
no, but
copy.
where is the affidavit to that effect or something? The registry note has to be there. Otherwise, how is anybody appearing on behalf of R2?
Yes, my lord.
Where is he?
My lord, today he is not present.
Then,
Yes, sir.
and his name is also not shown.
So may I pray that, my lord, this matter will take as a fixed item on 22/5/2000.
List this matter on
On 22/5/2000.
22/5/2024. Before that, you see, as prayed for by Mr. R. Soikia, learned counsel for the petitioner.
Your Honor,
Yes,
4 week time may be given.
for
4 week time may be given.
for what?
Because the petitioner counsel is undergoing treatment, so
See,
therefore.
an affidavit in opposition has been filed. Don't you want to file a rejoinder? You
Uh,
don't have that instruction. You
I
are a
have to-
proxy counsel here?
Yes,
Then why don't you take the instructions correctly? Why unnecessarily you waste judicial time? Every time this matter will have to be listed, some time is unnecessarily spent, no? So at least when a matter is listed, have the informations correct. It appears AO has been filed. You could have had the instruction and taken time for filing rejoinder. Yes, Yama. It appears that the affidavit in opposition has been filed on behalf of respondent number 1, 2, and 3. Stop. A prayer has been made on behalf of the learned counsel appearing for the petitioner that he
Uh,
is undergoing treatment,
yes.
medical treatment where? Out of
They are at
station.
Delhi, yes.
Stop. Let this matter be listed after
4 week.
after 3 weeks on a date to be fixed by the registry. In the meantime, the petitioner may file its rejoinder to the affidavit in opposition filed on behalf of R1, 2, and 3, comma, if he so desires.
Much obliged.
Yes, Mr. Patil, some AO where it was required to be filed.
Yes, no, my lord, the copy of my objection petition was served on the same day on the last occasion, my lord. Only on the question of maintainability. My lord, this petition has been basically filed being agreed by the ex parte decision. Now, my lord, since they have invoked the order 21, rule 22 of the CPC, my lord, the CPC itself provides the alternative remedy.
Order
21, rule 22 of the CPC, because notice was not issued. Lord, if that is the case, my lord, order 9, rule 13 provides the provisions when an order is passed ex parte. So, my lord, since there is an alternative remedy,
order
order 13, rule, order 9, rule 13, my lord.
Order 9.
9. Setting aside decree or ex parte against
So they did
defendant.
not prefer an
No,
application.
no, my lord.
And straight away come.
Yesterday has come. So, my lord, it is their prerogative to,
You could have filed an application under Order 9, Rule 13.
Lordship, the grounds for filing this revision is that Lordship, the demarcation order, verification order issued by Eastern Easement Act 1883, Lordship, that has been executed as stating that it is a Kabang decision. Lordship.
Where is the impugned order? Page, where is the impugned order?
Page number 29, Lordship.
29.
Yes, 29, Annex 1. May I read, Lordship?
Yes, please.
Whereas the Honorable Court of Deputy Commissioner, East Siang District, Pasighat, has communicated to undersigned by its order dated 25/5/23 that the matter pertaining to the land disputed Rag Lake area, Hying village in between Sri Yang Perme and Sri Okentine has attained finality with the competent court pronouncing Sri Yang Perme as the decree holder and Sri Okentine as the judgment debtor. Whereas
But,
proceedings,
where, this is the execution of the decree, from where it appears that this is ex parte.
Lordship, no notice was issued, Lordship. I have not received any
So
notice.
you are admitting that the 13 July 23 order is an ex parte order?
Yes, Lordship.
You are admitting?
Yes, Lordship.
Now, if it is admittedly an ex parte order, then an application, you can make an application under Order 9, Rule 13.
Your Lordship, that can be made, Lordship, but however, Lordship, with regard-
This court is not concerned with the merit otherwise.
yes, my lord.
Because if you are only aggrieved that this order has been passed ex parte number 1,
Yes,
correct?
Yes,
If that be so, then there is an alternative efficacious remedy available.
yes, Lordship. However, Lordship, Order 9, Rule 13, Lordship does not apply to execution proceedings, Lordship. It pertains to original suits, Lordship, and execution proceedings is not an original suit. In that case, Lordship, Order 21, Rule 105, Lordship, applies, Lordship. Order 21, Rule 105, Lordship.
No,
Lordship-
this Order 13 is not filed in an execution suit.
Yes,
It is filed in an execution suit.
Yes, my lord.
Huh? The Order 13, that order that has been passed is in an execution case.
Education, this is an education case.
Acha, Order 20,
1, Rule 105, Lordship.
when court may stay execution.
Yes, Lordship,
26,
105,
yes.
Order?
21, 105.
Order
Order 21, Rule 105.
105.
Oh, Lordship, 106,
Yes.
I'm so sorry, Lordship, 106,
10,
106.
yes.
Setting aside order powers ex parte. Rule 106.
Yes, yes.
The applicant against whom an order is made under sub-rule 2 of Rule 105 or the opposite party against whom an order is passed ex parte under sub-rule 2, sub-rule 3 of that rule or under sub-rule 1 of Rule 23 may apply to the court to set aside the order. And if he satisfy the court that
So no order shall be made on an application under sub-rule 1 unless notice of it is served on the other side. Then why this was not done?
yes, Lordship,
This provision are the same.
yes, Lordship, I'll be coming to that, Lordship. First thing is that Lordship, the decree, the said decree, they have executed, Lordship. It is not a Kabang decision. And Lordship, Section 27 of the Arunachal Pradesh Civil Code Act, Lordship, provides the proviso, dear Lordship, provides an execution for a Kabang decision, Lordship. When the additional deputy commissioner does not have any jurisdiction to execute a verification report, Lordship, the entire proceedings, Lordship, that was carried out as an execution proceeding, Lordship, was done without a jurisdiction, Lordship. Even saying that, Lordship, we come under Order 21, Rule 105, 106.
But once the order has been passed,
Yes.
you have a very limited say during the execution stage.
Yes, Lordship. Lordship, no such decree was passed, Lordship. It was just a verification report, Lordship.
All right, today this matter is fixed for orders.
Yes.
My lord, may I just make a submission, my lord? Now, my lord, this decision 16/12/2029, this is the deputy commissioner has deputed some people to go and see the matter. Now, then and there, they have come to a conclusion. It's only a question of a part. He has a resort there, and in order to settle that, they have settled it. I have also signed. He had also signed. His own younger brother, elder brother has also signed. My own family members has also signed. All the Gamburas have signed, and that decision has never been challenged till today. 16/12/2019, my lord.
This matter will need a full-fledged hearing.
My lord.
So, will admit it and post it for hearing,
My lord.
or it's already admitted?
My lord, a particular date may be given for disposal, my lord.
In fact, there is an order, today it was fixed for considering question of maintainability.
Yes, my lord.
You had raised that.
Yes, my lord.
Heard the parties, stop. It appears that a full-fledged hearing shall be required in order to ascertain whether the petition is maintainable or not. List this matter for final hearing on
28th of this month.
20 on 20th May 2024. So I will further clarify that the matter will be heard on merit.
Lordship.
You say that in order to decide the maintainability, the entire matter needs to be heard. List on so and so date.
Obliged.
Obliged, lordship.
My lord, I'm appearing for the state respondent, my lord.
Yes.
My lord, the leading counsel, Mr. Perme, my lord, I've been in, Mr. Perme. I've been informed that he's away.
It is submitted that the conducting counsel, Mr. L. Parme, learned counsel for the petitioner, is
He's away on a,
out of station. Stop. Accordingly, accommodation has been sought for. Prayer allowed, list after 2 weeks on
2
a date
weeks.
to be fixed by the registry.
my lord.
Yes, what about steps on R2?
Lordship, there is a inordinate, inadvertent mistake on that one.
When will you take it?
I'll take within
Mr.
ROU.
So and so learned ROU. Learned counsel for the petitioner assures that the fresh steps for service of notice upon respondent 2 shall be taken within a period of 2 days from today. Stop. List this matter after 2 weeks on a date to be fixed by the registry.
Deeply obliged.
So increment.
Interim, if any, shall be continued till
Next.
next date. Stop. Needless to clarify that if steps by the next date is not taken, interim order passed earlier shall automatically stand vacated.
Deeply obliged.
Yes, records have come.
Yes, your records is before your lordship.
Yes. Petitioner,
Perhaps absent, your lordship.
none appears for the petitioner when the matter is called. Mr.
And for the respondent number,
Mr.
S. Chetty.
S. So and so, learned counsel for R2 as and Mr. T. Ite, learned APP for the state respondent are present. It is submitted that the records have been received, records, these are LCR,
Yes, your lordship.
records from the court of
Court of Session, your lordship,
Court of District and Session Judge
Yes,
of Kumpare District, UPA has been received. Stop. Let the same be placed on record. List after 2 weeks on a date to be fixed by the registry.
yes.
Mr. Ite, you wanted to say something?
No, your lordship, these LCR as well as your lordship, the record which were before the executive magistrate was also called for.
That has
So-
also come.
Yes, I perhaps your lordship, even the same has been received.
You may just indicate what is
Yes,
to be
yes,
said in
Your
the
Lordship.
order. Yes. Respondent number 4,
Yes, services competition.
service, who is appearing for R4?
No one, Lordship. They,
Hmm?
as per the record, Lordship, there no one, Lordship. No one is filed any appraisal
It
number.
appears from the office note dated 12/4/2024 that service in respect of R4 has been received. Accordingly, service in respect of so and so stands completed. Stop. However, none appears today on behalf of R4 when the matter is called. List this matter after 2 weeks on a date to be fixed by the registry.
Lordship, I have an interim prayer. Lordship.
Interim,
No, Lordship, in this case, interim may be granted. Lordship says that
then we will fix it next week. List this matter next week for consideration of the interim prayer.
Like,
Definitely.
My lord, this is the same case, my lord, the council appearing in the, my lord, item number 6. They are also appearing in item number 19, my lord. Otherwise also, my lord, here, my lord, we wanted to file objection petition.
Where are they? They are not there today?
They wait for
have
the
not come.
correction. Wait for the correction of the, my lord, the item.
You want to file objection?
Objection, my lord.
Mr. M. Kato, learned, you're appearing as DYSG.
No, my lord, respondent number
Learned counsel for respondent
2 and 3, my lord.
2 and 3, 6, 1 week,
My lord, 3 weeks.
3 weeks time to file objection in the matter. Stop. Prayer is allowed. List this matter after 3 weeks on a date to be fixed by the registry.
My lord. Deeply.
On top, you say none appears for the petitioner when the matter is called.
I'm for the state, Lordship.
And record L. Lakshmi, AP, learned APP's presence. All right.
Deeply.
Here appearance M. Kato and L. Lakshmi. Yes. What is this criminal petition?
Yes, my lord. For quashing, my lord.
Quashing of?
Criminal proceeding.
Yes.
Joint settlement.
Joint.
Joint, yes, Your Lordship. Basis of settlement.
Affidavit has been filed by both, yes. There are 3 petitioners.
Yes, my lord. 2 accused and 1 is the victim of complaint.
Who's the victim?
Victim, petitioner number 3.
Petitioner number 3 is Nanuch.
Nanu Cheda.
And where is the settlement?
Our settlement is page number 100 to 100.
Page number 100, Your Lordship. Annexure 9.
All right. Heard, Mr. Your name?
T-Don.
T.
Don, D-O-N.
This is item 21.
20 years.
20, Your Lordship.
20. T. Don, learned counsel for the petitioner. Stop. Also heard Mr. T. Ite, learned APP for the state respondent. Stop. This is a joint application filed under section 482 of CRPC, read with Article 227 of the Constitution of India, seeking quashing of criminal proceeding and the FIR number 44 of 22 dated 25/3/2022 and corresponding charge sheet number 48/2022 in connection with GR number 244/2022 within bracket Itanagar WPS case number 44/22 registered under section 365, 482, 325 and 506 of IPC. Stop. The petitioner number 1 and 2 stroke accused along with petitioner number 3 stroke complainant victim.
Yes, Your Lordship.
Complainant stroke victim has jointly filed the instant criminal petition in terms of the settlement arrived between them, whereby their differences has been resolved.
Yes, sir.
Stop. Mr. T. Itel, learned APP for the state respondent, submits that he has received no instruction to object to the quashing of the said FIR. Stop. Third parties and peruse the materials available on record. Stop. It appears that the petitioner stroke accused along with the complainant stroke victim has jointly filed the subject criminal petition and accompanied by respective affidavits sworn by them and bringing on record the mutual settlement deed dated 28/11/2022 enclosed as Annexure 9 to the said petition, comma, whereby it has been brought to the notice of this court that the parties have mutually consented and settled the disputes and case arisen between themselves for peaceful coexistence as they were in relationship. Stop. A perusal, next paragraph, a perusal of the aforesaid settlement date indicates that parties have mutually settled the differences and misunderstanding and are living peacefully thereafter. Stop. In view of the aforesaid settlement and endorsement made by the learned counsels for the parties, comma, this court for the ends of justice set aside and quash the criminal proceeding and impugn FIR number 44 of 22 dated 25/3/2022 and corresponding charge sheet number 48 of 2022 in connection with GR number 244/2022 within bracket Itanagar WPS case number 44/2022 for the 22. Stop. With the aforesaid observation, the petition stands disposed of. This detail you will find at page 21.
Yes, Your Lordship. Deeply obliged. Your Lordship, in item number 17, Your Lordship.
This is
No, Your
totally
Lordship.
disposed of.
Yes, yes, yes. Item number 17, Your Lordship, the LCR pertains to the session court as well as the record from the executive magistrate was called for. LCR, so far as the record from the session court has received, but not from the, Your Lordship, executive magistrate Itanagar.
So reminder is it to be
Yes,
sent
yes, Your Lordship.
in item 17, you say that further reminder be sent
To the executive magistrate Itanagar Capital Complex.
for the records from the executive
Magistrate Itanagar
Itanagar
Capital Complex.
Capital Complex.
Record pertain to Harry Teji versus Bamang Taka.
Mr. Ite, if
Yes.
you don't mind, please put it in a
Yes,
slip
yes.
and give it. to
Okay,
her, Then
boss.
there will be no confusion.
Yes, Your Lordship.
Through the registry of this court. Okay.
That much, Your Lordship. Deeply obliged.
Mala, this is also the.
I just take a 5-minute break, Mr. Counsel.
Defect, my lord.
My lord, that has been rectified. I believe the file is sent, lordship. Lordship may call for the matter as and when lordship deems fit, my lord.
No, I think we have passed an order there to list it after the rectification.
After rectification that is done, lordship,
So
are
then
praying for the
registration
matter to be listed,
listed.
my lord.
If you want the registration listed, I think that order has been passed.
So lordship, may I pray the matter may be listed today, my lord?
No, not today. The other side is also not here right now. Not today, Monday at best.
Lordship, then once they're here, lordship, then we will place the prayer, my lord.
Mr. Vaidya, this court has already passed an order.
Yes, my lord, as your lordship deems fit,
Correct.
my lord.
So
We'll make a request to the registry,
you
my lord.
make a request to the registry.
My lord.
Yes, call for the next matter.
My lord, this is also joint application under section 482
Okay,
in connection with the Janging PS case number 5 of 2023.
affidavits are there.
Yes, my lord. Now my lord, the dispute is between the my lord wife and husband. The informant is the wife and the accused person here in the as a petitioner number
What is the
one.
name of the complainant?
Complainant, name of the complainant is the is as a my lord petitioner number 2, Shrimati
No, her affidavit is not there.
Yago Pankam.
Her affidavit is not there.
My lord, his
Miss
her
Vivek?
affidavit is not there, my lord, but despite that, my lord, he has been authorized to sign, my lord.
Authority is not good. If it's a
Yeah.
joint application, the affidavits of both parties ought to have been there. You see, then
My lord,
it is easy for this court to, otherwise you're aware.
that is there, my
it
lord,
is
that I
completely
accepted.
the discretion of this
But-
court to compound it when there are non-compoundable offenses are there.
My lord,
So you bring the affidavit.
my lord.
How much time?
My lord, 3 weeks time, because it's far away from
right.
the,
Mr. So-and-so, learned counsel appearing on behalf of the petitioner seeks 3 weeks' time to support the joint application filed by the complainant and the accused along with an affidavit by the complainant. Stop. Prayer is allowed. List this matter after 3 weeks or a date to be fixed by the registry.
Amen.
Yes, Mr.
My lord, I have
Singh?
submitted
Yes,
my.
yes, I have got your suggestion. What about
Lordship,
the,
I will submit mine.
you're submitting today?
Yes, Lordship. I'm
But there is only one difficulty. You have not argued on merit.
Yes, Lordship. All Lordship in my written.
No, that cannot be. You can't argue in written arguments. The other
Yes.
side has a right to rebut.
Yes, Lordship.
Unless you argue, how will the other side reply?
So Lordship, then Lordship next week, Lordship. Yes.
Because it's the first appeal.
Yes, Lordship.
It's
Yes, Lordship.
the last court as regards facts.
Uh,
You have rightly pointed
Yes.
out. Santosh Hegre,
Mm.
that decision is also there. Anyway, then pose this next week for hearing.
Monday,
I
madam.
will submit, Lordship. I will submit.
Monday?
Yes, Monday or
Yes,
Monday,
next
madam.
week.
let's see.
Because the first
Okay, Lordship.
technical issue they have raised is not even correct.
Yes, Lordship.
That's right. You see, it will be very easy to dismiss only on these 2 points. But the
That's what-
first
that's what-
round
yes.
is not taken, it was never taken up. It's a new plea.
Yes.
You cannot raise a new plea
Yeah.
by
And
way
then
of
it's an
the first attempt.
incorrect plea also.
Correct.
Mm.
And you are absolutely right, those issues
Yes.
which has already been set aside by the Supreme
Yes,
Court.
exactly.
How, on what ground they will be
exactly.
adjudicated by the court below. So, but those are only technical grounds.
Yes, yes.
Now the
That's what I was pointing out. How can
You're
this-
right. It would be difficult for
Yes.
this court to merely
Yes.
dismiss this appeal only on these 2 grounds
Yes.
without looking into. Of course, if we are affirming the decision of the court below, this court need not go on an elaborate
Yes.
analyzing of those facts,
Yes.
but some reasoning has to
Yes,
be
yes,
given.
yes.
Anyway,
I will submit my written arguments.
वो 2 point में है ना.
you're submitting it right now.
Yes, I submit, Lordship.
You
Written arguments.
submit.
So you're submitting it now, or you're going to submit it by Monday?
All it.
Give a copy to Mr.
Yes,
Bangi.
yes, I also.
It
give
is submitted on behalf of the petitioner that a written, Marsha, cancel it, you write like this. Heard Mr.
Mr. Jiva.
Mr. G Barn, learned counsel for the petitioner, also heard Mr. D. Penging, learned counsel for the respondent.
Number one.
Number one, stop. A copy of a copy of the written arguments has been submitted on behalf of the respondent by Mr. D. Panging, learned advocate for the petition for the respondent number one yesterday. Stop. The same is kept on record. Stop. Pertinent to state that the aforesaid argument filed on behalf of respondent number one pertains to the technical argument made by the petitioner on the last occasion. Stop. Today, however, when the matter was called for hearing, the petitioner has said that the petitioner seeks the petitioner has submitted that the petitioner has prepared written argument both on merit and the technical grounds. Stop. That being so, comma, unless the arguments are made on merit, the respondent number one shall be prejudiced. Stop. As such, let the parties exchange the written arguments and let this matter be taken up, let this matter be listed for hearing on
6th of May.
on 6/5/2024.
Okay.
And interim may be continued.
Interim, if any, shall continue till the next date. None appears for the petitioner when the matter is called. List this matter. You're appearing. Petitioner. None appears for the petitioner when the matter is called. Stop. Mr. G. Talo and Mr. T. Tayang, learned counsel for the respondents are present. Stop. List this matter for hearing.
Next week could
Yes,
be
give me a date. For hearing on such and such date.
Six and 19, item number 19. 19 maybe, sir. 19. Because we said for Okay, okay. हाँ, हम लोग भी उल्टा पीछे देख के जब मेटर खोल के हम सब क्वेश्चन बोलेंगे 24 बोला ना हम दोनों है तब तक ऑर्डर पास करा इसलिए हम लिए मंडे ये मंडे को तो सर हम नहीं उससे पहले हम सीधा लास्ट में होगा सिक्स के लिए भी वो बैक वहां जाए क्या मेरे पास जो लिखा हुआ है
May I please your lordship?
1 second. Yes.
May I please your lordship?
Please, sir.
My lord, we have instruction not to press this bail application.
Just wait for a minute. Just wait for a minute. Mention is being made here. Just wait for a minute.
Yes, sir.
All right. All right. Yes.
Item number 1, bail application number 1212 of 2024.
May I please your lordship?
Yes, you want to withdraw it?
Yes.
Yes, my lord.
Your name?
M. Alam.
Heard Mr. M. Alam, Learned Counsel for the petitioner. Stop. Also heard Mr.
DP Goswami.
So and so Learned APP for the state respondent. Stop. Mr. M. Alam, Learned Counsel for the petitioner, submits that he has received instructions from the petitioner that the petitioner does not desire to press the bail application. Stop. In view of the aforesaid endorsement, the bail application stands disposed of on withdrawal. All right.
Thank you.
M Alam is M Alam. AM. Yeah, Alam. And I don't know the public prosecutor name. No? Okay, I will try to collect her. Yeah, I don't have number. I have two different postmaster number, but whether they are secure or not, no? Let me confirm.
Last week order, this was the order to be transferred.
Wait, no, hello. अच्छा हम लोग आज डीसी लेटर किन्हें पे कौन से बारो? अच्छा ओके अच्छा ये पीपी का नाम क्या है बारो? डीपी गोस्वामी. ओके थैंक यू हाँ. डीपी गोस्वामी.
The last week order, no, that is Guwahati mental disposal, it was sent to Guwahati.
Oh,
So, do you remember
record.
your report? Whether it's sent or not, because today Guwahati, they have not received yet.
Oh, bail application.
They are like.
Oh, I don't know regarding that, no? Let me consult on the section and check it out.
So, this measure also, for any measure, original signature, original fund, and then the original, the signature, which need to be carried to Guwahati.